Right, okay. We are back. We're back at Hazel Solicitors Manchester's office. Yeah. From Manchester, we seem to be doing a lot of things. But first of all, here is my colleague Rahim. Rahim is from the Personal Injury Department of Hazel Solicitors, and myself. I do work in personal injury as well, and in family law, as well as immigration and nationality and human rights. Hello, Rahim. We're back with our viewers today.
Hello, everyone.
So, what Rahim and I are going to discuss today is with regards to the relationship between a client and the lawyer. So that relationship, right? That is the focus of our business, isn't it?
It is, yes.
Yeah. I mean, we have clients. They are everything. You know, that's the reason why we are lawyers, and that is the reason why we are happy doing what we do. Because once we provide the services successfully, like we always do, then obviously our clients are happy. And what do? They go and tell others. They do the marketing for us. So that relationship between our clients and us, or generally speaking, the relationship between a lawyer and the lawyer's client is vital. So what I'm going to say, I'm going to give an overview of that relationship, and then Rahim obviously will be dealing with specifics with regards to that relationship. Yeah?
Yes.
Now, once a lawyer starts working for a client, obviously there is a contract. And that contract, which sometimes we refer to as a retainer, is very important. It's like any other contract, which means there are obligations and there are responsibilities. So, Rahim will be looking at a case of litigation. Now, if you are running a litigated matter as a client, whether as a claimant or as a defendant, but we are going to talk today from the perspective of the claimant, right?
Yes.
That is someone who is suing someone else, as we say on the streets. Now, we receive a client who wants to sue someone else. Let's take a hypothetical figure of £50,000. And we start the case by signing a contract saying that we are going to provide the legal services, and you, the client, you're going to pay us a fee. Sometimes, because of the cost of legal services, clients may not be able to pay the fees. And where that is the case, and if in the assessment of the lawyer, the case is a case with good prospects of success, the lawyer may make a funding arrangement with the client, so the client will not have to pay upfront for our fees. What that means is we would sign a conditional fee agreement. On the street, it is known as no win, no fee agreement, right? Now, this conditional fee agreement would enable us to work on the file, work on the case until the end, and when we win the case, then our legal costs get paid. So this relationship is based essentially on the fact that in our assessment, the case is a good one. So it is a risk that the lawyers will normally take, and at the same time, it is an opportunity for claimants who cannot afford legal fees to also access justice by being able to have legal representation for their case. Now, in the case of a litigation, there are lots of things at stake, and this contract between us and the client is under continuous review. Now, this brings me to the topic of today, which is, can a lawyer come out of a case very close to the final trial? Now, this is a massive question. because the answer to this, which Raheem is going to look at, is not clear cut. It is yes and it is no. Can a lawyer come out of a case 2 days, 3 days, 1 day before the final hearing? Because the implications are huge. What this means is your client will be left without representation. Sometimes a court may say, hang on a minute, you the lawyer, you have huge responsibilities. You can't just abandon your client close to a final trial. Because if you do that, then essentially you are destroying your client's case. And not only would your client lose possibly their case, but they would have financial implications because the cost of the other side would be borne by the client. And sometimes we're talking of huge sums of money because, as we've already seen, legal fees are high. So in a case where the hypothetical case I mentioned, where we are representing a client for a case worth £50,000 of damages, if a lawyer comes off very close to the trial, the risk is the client may end up paying the other side cost, which may be more than £50,000. And because the consequences are enormous, that question, can a lawyer come off a case very close to the hearing, is a massive one. And that is what Raheem is going to be looking at. Raheem, so how do you answer this question? Because some of the viewers will be thinking about it now, and why would the lawyer leave me at the end towards the final trial? Or alternatively, yes, but why not? It is a contract, and if there is a breach, why would someone not come off this contract? There must be duties and responsibilities.
Yes.
So how would you approach this, and what would be your answer?
Well, it's very complicated to begin with, like you've previously mentioned. It's something that we don't like doing.
No.
Something we take. We discuss and think hard about before doing. But there are cases where as a solicitor, you have to stop acting on behalf of your client. There are a number of reasons why you may want to do that. The most common is a client not taking your advice. For example, if there are risks in the case, risks to your client losing the case and having to pay legal costs to the other side.
So what you're saying there is you have taken on the case
Yes.
with the belief that the case has got good prospects of success. And at a certain point, you've discovered that, oh, hang on a minute, evidence has come to light, this case has got loads of risk, and you're advising your client to back off.
Yes, either discontinue the case or make an offer of settlement prior to trial. Another common example is where the other party, just before trial or a couple of days before trial, make a very good offer of settlement, which is reasonable to us lawyers, given the risks involved and the risks of going to court and losing. I don't know if you've covered in your previous topics, a Part 36 offer and the consequence.
No, maybe we're going to do that subsequently.
Yes,
in another.
I won't go into detail.
Yeah.
But in law, if you receive or if a party makes a offer, which is known as a Part 36 offer, and the receiving party does not accept the offer, and later you go to a trial, a court hearing, and the judge awards you damages which are less than what you were previously offered by the other party, what that in essence means is that at the end of the case, the other party can ask the court to award costs against you. So again, not going into too much detail in the summary.
Yeah.
A Part 36 offer is open for a period of 21 days. And what the rules say is, if the offer is accepted within 21 days, the other side who is making the offer will bear they'll pay your costs up until the end of the 21-day period. If you accept the offer after the expiry, which is after 21 days, then the other side will be liable to pay your costs up until the 21 days after the offer is made. But then you would be liable to pay the other side for their costs from the expiry of the 21 days. So basically, what I am trying to
that's a bit complex for a litigant with limited experience to grasp. But I think the way you're presenting it, it does come to one conclusion, which I'm sure you're going to get to now.
Yes, which is, if we receive an offer of settlement and we think it's a good offer, we advise the client of the risks of not accepting the offer, and our advice to the client is to accept the offer, and the client does not wish to take our advice, and the client instructs us to proceed to trial, where we know we are not going to beat that offer, or we're not going to get more damages than what are offered at this point. That is, at that point, we must then consider whether we can continue acting, because we always have to think in the best interest of the client. In this scenario, if we don't accept the offer and we advise the client to accept the offer and they don't accept, and there are cost consequences, then in essence they're going against our advice. So that might be a scenario where we may consider coming off court record, because to proceed to trial or to continue with the case, you would be incurring more legal costs. Another most common, in personal injury cases, a common example is where the client goes to a medical expert. So they go to a medical expert, they tell the medical expert one thing, and then when the medical report is prepared by the medical expert, we receive the report, we notice that the accident circumstances or the facts stated in the medical report are different to what we have been previously told by the client. So that causes a bit of a conflict in that case. So that's one example. That's another example.
So just to summarize, when it comes to light that there is a fundamental conflict of interest, then it is justifiable for a lawyer to come off a case very close to a trial, which is critical. A conflict of interest, from what you've outlined there, it's a serious matter.
Yes.
So, in effect, that is an example. Now, a client actually made an inquiry, and that is what led us to try to discuss this topic this morning, right? Because a client wanted to know if his lawyer can come off his case because he owes money to his lawyer. So he's got these accumulated legal fees. It's not a conditional fee agreement, the type that I explained earlier, where your lawyer does the work and you do not pay up front, and if the lawyer wins, the lawyer gets paid, obviously, for your damages. But this case inquiry that we received, it's a fee-paying hourly rate arrangement. So the client arranged with the lawyer, and they entered into an agreement that the client is going to pay the lawyer the fees, and the client has not paid the fees, and this accumulated, and it was very close to the trial, and the trial itself was a 2-day trial. So the lawyer had to proceed to arrange representation to attend the trial. So the cost for legal fees was going up and up and up. We all know how this can rapidly escalate, right? So the question was, can my lawyer really leave my case 2 days before the final trial? There is a categorical answer. And what's the categorical answer?
Well, my opinion would be no.
Definitely a big definite
Just
no.
because the fees are outstanding. That isn't a valid reason.
That's not a valid reason. So I think what we should take off the video today is not only the example of when a lawyer can come off a case, but I think this example of when a lawyer cannot come out of a case close to a final hearing. Now you see, this is one of the duties of a lawyer, where we owe this to our clients, we owe this to the public, we owe this to the courts, because of your fees, you as a lawyer, you cannot abandon your client close to their hearing. If you think your client owes you money in terms of legal fees, don't jeopardize the interests of the client. Attend the client's hearing, conclude the trial, and if you think your client is still not paying you, we know what to do. We are lawyers. What do? Obviously, issue proceedings, sue your client, take your client to court for your legal fees. But you have to finish what you've started. And if there is outstanding payments for legal fees, go and pursue your client for the outstanding payment for legal fees. Do not, and this obviously is for us the lawyers, do not abandon your client. So I think what we get from the video today is, yes, there are circumstances when we can not definitely leave a client before a final trial, but there are circumstances when we can. And these circumstances has to do with the overriding objective of justice, us the lawyers being officers of the court. A client comes to you and say, well, the truth in the matter is, all what I've been telling you from the beginning of the trial, or the beginning of the case, is untrue, but I don't want you to tell the court. Of course, the lawyer would not lie to the court. As officers of the court, what we would do is, we would advise the client that you have to tell the truth now to the court, and that is what we're going to do at trial. And if the client says, no, I don't want to do that, it is a good reason for your lawyer to come up out of record. So there are loads of reasons which we would say are good reasons when a lawyer will come off record, but not the example we discussed earlier, not for non-payment of legal fees. So I think that is the food for today, right?
Yes.
For today morning.
Yeah.
So we're going to carry on in Manchester. What have you got today, Ryan?
I've got another trial to prepare for.
Oh dear.
I've got
Right.
a trial tomorrow.
Okay. Which court is it for?
For Manchester.
County
County
Court?
Court,
Right,
yes.
okay.
This
Yeah.
person injury road traffic accident claim.
Right, okay.
Yes.
What's the value of that?
8.5.
£18,500.
8.5.
Oh, £8,500.
8.5.
Right, okay. That's definitely not a multi-track,
No.
right? Good luck with that,
Thank you.
and we'll catch you later on. And thanks for watching. Take care. Bye from Manchester.
Bye-bye.